Hello everyone, welcome back to LiveLaw Academy. We are back with another great judgment, this time with the discussion on Consumer Protection Act and to find out whether the Consumer Protection Act would be applicable with respect to the services given by the advocates. So this is the discussion very important if you are a lawyer. This is the discussion very important if you are preparing for judiciary or if you are a student of law, for you to understand how in 2024 this judgment has basically overturned the decision given by the National Commission or Consumer Commission. So stick to us and we'll be understanding and we'll be referring to this case of Bar of Indian lawyer through its president Jaspreet Singh versus DK Gandhi. So what are the facts of this case to understand? Before I get into the facts, I'll just briefly tell you as to what is going to be the way of understanding this particular case. This is a case wherein we will see there are different forums under the Consumer Act. The Consumer Protection Act, if you're preparing for judiciary, you must know that there are changes introduced by the 2019 and from the 1986 Act. So therefore, it becomes important for you to trace down that what are the changes that also becomes relevant in our discussion in today's class as well. So just keep following these provisions as well, just keep reading all these things when you are referring to this present case, because in your exam you can expect a question on this as well as any related question which will be covered under Consumer Act as the changes introduced in 2019. Okay. So now what are the facts? If I give you facts, if I tell you that, let's say you have a client, the client reaches to you. So we have, let's say X is a client. The client reaches out to the lawyer and this is Y. He's the advocate appointed for a particular case wherein X tells Y that Z had given a check to X and the check has bounced, right? So in such a situation, the check was, let's say, for 20,000 rupees. And he also, in the suit that he would be filing, Y would be filing on behalf of X, he also asked for 5K or 5,000 rupees to be given as the cost incurred by X for instituting this particular suit. Now, what has happened here is that Z actually admits and says that, all right, I will be paying both the promised amount to the advocate. He hands over the checks also to the advocates. And now, what do you think is the duty of the advocate in this given situation? Is it to hand over the check to the client, or can he keep those checks to himself, stating that you have not paid my fees? Okay, that dear X, dear client, you have not paid my fee to me, and therefore I would be keeping these checks to myself. Now, while the advocate was doing so, what has happened here is the advocate also decides to file a suit against his client, a suit for recovery. He says that my fees has not been paid to me and therefore I am filing a suit for recovery of the money that is to be paid. In addition to this, X is aggrieved here. X realizes that the checks were supposed to be given to me. My advocate has not delivered the checks to me. So therefore, he also goes to the consumer forum, right? So under the Consumer Protection Act, we recognize a hierarchy of of the forum with respect to any consumer dispute. We recognize that you will be reaching out to district, then you will be going to state, and then from there you can reach out to the National Commission, National Consumer Dispute Redressal Commission. So this hierarchy was followed in this case as well. X reaches to the district, from there appeal was filed to the state commission, and then ultimately the National Consumer Commission holds that lawyers or this advocate falls within the ambit of Consumer Protection Act. So this is the background, all right? These are the facts as to why X in this case felt that his advocate was deficient in the service provided to him. He feels that because he was deficient in the service provided to him, he can or he has the authority to reach to the consumer forum, and that is how he has done so, highlighting the deficiency in services by the advocate. The advocate has also filed a recovery suit wherein he says that I am entitled to recover the fee that is supposed to be given to me. Now, when this particular dispute was before the consumer forum, what is important is that the advocate challenges this on the question of jurisdiction. The advocate says that this particular forum, that is the Consumer Dispute Redressal Forum Commission, doesn't have the jurisdiction to entertain the suit because advocates for the services that they render do not fall under Consumer Protection Act. Okay, so what do we have to find out here is, that is our basic question, that whether advocates for the services that they are giving, okay, whether they will fall under the Consumer Protection Act or not, whether they are services or whether they are professionals as per the Consumer Act or not. If yes, let's say if professionals are covered under Consumer Protection Act, whether legal professionals are different from all the other professionals or not. So we have medical professionals, we have various other classes, right? So whether these legal professionals are sui generis or are distinct or unique in any manner or not, that is the other question that is to be discussed. And the third one is, let's say that legal professionals, even though they are sui generis or the profession is sui generis, despite of that, we will see whether they would still fall under the definition of service given under Consumer Protection Act or not. So what have we covered so far? We have understood that in the given situation, there were services that was given by the advocate. The client feels that there is deficiency in the service. The client takes this particular matter to the consumer forum. The advocate challenges it on the ground of jurisdiction, and that is the answer that the Supreme Court would be giving now as to whether the advocates for the services provided by them would be falling under the Consumer Protection Act or not. Why yes or why no? The reasoning also has been given. Then important aspect is whether legal profession is sui generis or is different from all the other professions. Because we had a previous judgment of IMA versus VP Shanta, Indian Medical Association versus VP Shanta, 1995. Wherein the Honorable Supreme Court only had held that the medical professionals fall within the ambit of Consumer Protection Act. So whatever the medical professionals are doing will be falling or will be governed or will be regulated by the Consumer Protection Act. So that is why this question, that are we different? Is legal profession different from medical profession or not? This is also important for us to understand. Okay, so I hope you've understood a brief idea about the fact of the given case. I'll take you to the copy of the judgment for now, only for you to see the name of the case. Okay, so if you see the parties here, after the National Commission decided that the advocates would be covered under Consumer Protection Act, all these are the stakeholders who have challenged it. So Bar of Indian Lawyers, or we talk about Delhi High Court Bar Association, we talk about Bar Council of India, or we talk about the advocate himself. All of them have challenged this versus BK Gandhi, that is the client of this particular advocate. So that is how the name of the case goes ahead, and this I hope will help you remember the name of the case as well, because in your judiciary examination you can definitely expect questions straight away being asked from why what is the name of this case and what are the key points decided in this case. So you must remember the name of the case as well. All right, and almost in every class that we have covered so far, I have told you that how you can remember the name of the case. We did Sita Soren versus Union of India. I told you how the name is relevant in context of her being a political leader. Then we referred to, in the previous class, we also spoke about Sukanya Shanta, and I told you that how she's a journalist and she reached out to the court. Now, here you have an advocate, and you understand that all these are the stakeholders who have reached to the court challenging this particular order passed by the National Consumer Dispute Redressal Commission. Okay, wherein they said that yes, advocates for their deficiency in services would fall under the Consumer Protection Act. I hope this far I have been clear to you. If you have any doubt, you can please, drop your doubts in the chat box or in the comment section, and I would be more than happy to entertain those. All right. Now we move to the questions, and now we move to the argument as to how do we really feel this is going to be different. So these are all fact and which I have highlighted. I also told you that jurisdiction was challenged by the advocate in the given situation. All right. Now, what are the arguments and what are we supposed to know? So, firstly, we understand that we are here talking about Consumer Protection Act. Whenever such a question arises as to whether this issue will fall under this law or not, we always can see what is the nature of the statute, right? What is the nature of Consumer Protection Act? And when you say, let's say in a given situation, there will be pros and cons of you allowing, or of the Honorable Supreme Court allowing the matters of services given by the advocates to fall under Consumer Protection Act. And these will be two facets, right? So what are the pros and cons of it is something that we can understand. If I say they should not be covered under Consumer Protection Act, do we have any other law by which we can say that yes, they may fall under this? We have Advocates Act, right? By which, if not Consumer Protection Act, we have Advocates Act, by which we have the state bar councils, as well as we have Bar Council of India, which regulates or which has the power to take disciplinary action already. So if you feel that you have any grievance, you already have a platform by which you can get the remedy for all your grievances. But on the other side, here we are asserting, and here we are saying that we want it to fall under Consumer Protection Act despite of this. So for it to fall under Consumer Protection Act, we will have to see that whether it suffices or whether it actually fulfills all the essential of services, so to say, under Consumer Protection Act. So I will take you to the copy of the law now. Let's go to the Consumer Protection Act. So this is the copy of Consumer Protection Act. Whenever you read any law, whenever you are trying to find out the scope of the law, right? Because here we are trying to understand. Nowhere in the previous the amendment that have been made, nowhere it has been clearly mentioned that the professionals giving these services like medical aid, education, or when we talk about lawyers, nowhere it has been clearly mentioned that they will be covered under Consumer Protection Act. So whenever there is an ambiguity, you will have to find that what is the aim, objective, motive of introducing this law, right? And for that, you start and you begin with the long title or the preamble of the law itself. So I'll just summarize and I will tell you that what has the court held in this given case. The court says that the idea of introducing Consumer Protection Act 1986, or when we talk about 2019, wherein a lot of changes have been made. Now, these changes have been made keeping in mind that we realize that yes, we have to recognize something called as product liability. Why? Because that is something that is that is the need of the hour. We recognize that there are ADR mechanism that we will have to acknowledge, and we will have to say that yes, this must be there in the society. We recognize that we have misleading advertisement, and this must be addressed by the Consumer Protection Act 2019. So all these were the issues that have been addressed by the law. But we also saw that the idea of Consumer Protection Act emanated wherein we saw that there was deficiency in services, or the goods that were given were not of the good quality. Therefore, this majorly was made or was introduced with an intention of serving better business practices or better trade practices. Now, when I write business and trade, and on the other side, I am writing professions, do you think there is any distinction? Do you think a person who is a businessman is equivalent or is any manner same to a person who is a professional? Or is there any distinction? A person exercising trade, is he anywhere different from the person exercising his profession? So there is a distinction, right? We acknowledge and we understand that as well. So the judgment basically addresses this concern. It says that we are very clear that the intention of the law was to address this, that whenever there are wrong business and trade practices, we understand that we will have to address it. But for a professional is different. How? Because there are definitions that I'll take you through. But a professional is different because a professional will be, his act will not be mechanic and rather more mental. So these are different definitions given, to differentiate between these two classes. A professional would require a certain set of skills, certain skill of qualification for him to be called as a particular professional, right? Especially in our case, you can be a lawyer, but without you getting a wakalatnama signed, without you, taking the consent of the client, can you really be, representing that client? That is not so, right? So therefore, the court said that we recognize that the Consumer Protection Act was introduced keeping in mind this aspect, that whenever there will be deficiency, whenever we will see that the business or the trade practices are not good, we will pitch in and the Consumer Protection Act will try to protect it. But nowhere do we see that's this trace of professionals or a deficiency in the services of the professionals to be covered by the Consumer Protection Act. Okay, so this is one part of how the judgment is seeing an advocate's profession to be different from that of a business person, from that of a trader delivering some goods or services to you. Then in addition to that, we also see the long title here. It says it is an act for the protection of interest of consumers and for the said purpose to establish authorities for timely and effective administration and for settlement of consumer dispute for matters connected. Timely and effective administration. Now, how has this been done and why has this been done? And this is also one of the concerns because of which the Supreme Court has been hesitant in recognizing and in saying that yes, we will allow the advocates and the services rendered to fall under Consumer Protection Act. See, the idea is that you bring efficiency in disposal of these cases and in disposal of these concerns. So these summary proceedings that are there. Now these summary proceedings, because we understand that this will be disposed of very quickly, this will be an enticing factor. And minded, I am not saying this has been quoted by the judgment itself, that this is going to be an enticing factor for a person, for a litigant who feel that he has been wrong, who feel that okay, I have a very huge grievance to be addressed. He would want a very speedy disposal to be done. And therefore, if we open the window of allowing advocates to fall under Consumer Protection Act, it will just open floodgates of multiple cases being filed in multiple forums. So therefore, we have to see holistically as to whether what will be the pros and cons of allowing the advocates and the services rendered to fall under Consumer Protection Act or not. So reading the long title itself, we understand that because the idea is to dispose of the case in an immediate manner, in an efficient manner, we absolutely respect that fact. But we also understand that any frustrated litigant would want to reach out to the Consumer Protection Act for the remedies. And in that situation, there is a possibility that, they may actually distort, or they may actually go to reach out to multiple forums and try to seek remedy for the same. This also tells us that, this was done with an intention that if these goods or services, whatever has been rendered to you, if there is deficiency in it, you must get it addressed in a very immediate and a timely manner. So that is why this discussion has been done. Now we do not stop anywhere. We go to section 242. So I'll take you there for the definition of services. All right. So we have defined the term service here. Now take a moment. You can pause my video here and try to find out the definition. What is the nature of this definition? My first question is, as a student of law, you must first answer this question, that what is the nature of this definition? All right. I hope you've paused my video. I hope you have tried to read it. Service means service of any description which is made available to potential users and includes, but not limited to, the provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical or other energy, telecom, boarding or lodging or both, house construction, entertainment, amusement, or the purveying of news or other information, but does not include the rendering of any service free of charge or under a contract of personal service. So the first question remains the same, that after reading this definition, what is the nature of this definition? So is it explanatory? Is it inclusive? Is it exclusive? What is the nature of this definition? Either of the three, two, or all three? So the answer would be that it is explanatory as well as inclusive as well as exclusive. Okay, so these are questions that you can expect in your interview, that they may ask you. But once you say that I really like interpretation, they may ask you that, okay, do you have anything in mind wherein the different ways or different nature of definition has been used in a particular singular definition? So how is it explanatory in nature? Let's try to understand. It is explanatory because it uses the term means. Okay, I am highlighting and using the same color. It is inclusive in nature because it uses the term includes. And lastly, it is let me use which color, so we take pink. Okay, so it is exclusive in nature because it clearly says but it does not include. Okay, so these are the three nature of this particular definition. This definition, because the makers of this particular law realized that we cannot really give an exhaustive definition of service, because there will be multiple things that will keep coming with time, right? So therefore, they tried to put a list here, and that is why we say it is an inclusive definition. Then also they have tried to define it by saying that it is something which is available to the potential users. So that is how it is an explanatory definition, which is trying to some extent explain something. And it also excludes certain things. It says that, okay, you may include other things here, but we are excluding two things from the ambit of service. One is contract of personal service, the other is service given free of charge. This is our concern. Okay, for my case, for my present case, for my understanding of whether advocates would fall under Consumer Protection Act, my concern is contract of personal service. Whether the services rendered by this lawyer is a contract of personal service or is a contract for service. Okay, so keep this definition in mind and let's try to understand what this basically means. All right, so I'll explain this to you now. What is contract of personal service? And we will come back here again to understand whether service falls here or not. So there are two types of contract in this context. One can be a contract of service, and the other one can be a contract for service. So we highlight this is of and this is contract for service. All right. Now, how are these two different from each other? Is there any distinction? I am sure you must have. If you have studied vicarious liability, you may have heard of this. But just to simplify, if I have to answer, I would say that in contract of service, okay, this can be understood. While there are various tests for these two to be distinct in nature, I will be sticking to one because the judgment revolves around one. Okay, and we are not studying the concept, rather understanding the judgment here. So the test of control has been used. It says that in case of contract of service, the control will be higher. Higher the control, higher the chances of it being a contract of service. Lower the threshold of control, lower the chances of it being a contract for service. Okay, so that is one way to understand. If you say that between the master or servant, between the advocate and the client, if the control of the client is a lot more on the lawyer, we can say that it is contract of service. If the control of the client is much more lesser or is almost minimal, we will say that it is a contract for service. Okay, so this can be a basic idea for you to know what is contract of service and for service. Now, ma'am, how do we find out whether the client has control or not? Is there any fact? Do we have any information on this part to see how do we assess control? So the court has answered. The court firstly, as I gave you a hint also, the court firstly held that we recognize and we understand that whenever the you may be a lawyer, you may already have qualified, you may already be enrolled also, but in all these situations you will still not be considered to be to go and represent any particular case unless and until the wakalatnama has been given to you, unless and until you have an authority and consent of the client to represent the client in the court. So that is one thing that they have tried to explain it with the example of wakalatnama. The other one is that the court says that it is the client. When we talk about medical professionals, your client will not come and tell you how to do the surgery, or sir, do not use this medicine, use the other medicine, do not use this syringe, rather use the other one, right? All this is not done when we talk about the medical professionals. But in case of a legal professionals, it is the client which also tries to, which will navigate the matter, right? Who will introduce you to facts, who will introduce you to the availability of documents and various other things. So this is the other thing, that the involvement or control of the client is much more higher in case of a legal professional for it to be considered as a contract of service. Then we also realize, and by this we are also finding the answer whether legal professionals are sui generis or not. Okay, so the court also says that we recognize and we realize that a lawyer has multifaceted duties. He is not just a lawyer to the client, he is also officer of the court. Now you would be seeing this particular statement being used in so many judgment recently, that an advocate is the officer of the court, and therefore here specifically they have said that the advocate has four faceted duty towards his client, towards the court, towards the society at large, and towards his colleague and his counterpart. So that is why the lawyers also have this particular duty. But does it fall under contract of service? Yes, because of these reasons, because of the involvement of the client, because of understanding that the client will be giving you the authority and the control of the client will be much more higher, and therefore it must be classified and it must be called as contract of service. Now, the minute I say that it must be considered as contract of service, we go back again to the definition. Does it include or does it exclude contract of personal service? It excludes. So, a service given under Consumer Protection Act, if the service is of or is based on a contract of personal service, it will be excluded out of the ambit of the Consumer Protection Act, and therefore it will not fall under the ambit of consumer law. So this is a very simple solution, simple way of understanding that because it is a contract of personal service, it's specifically very clearly mentioned to be have excluded. It will not fall under the Consumer Protection Act. But that only gives us the answer to the first question. Did the legislature ever intend to include professionals or services rendered by the professionals within the act? So from this first part, we say that no, that is not so. So what have we read? We refer to section 242 of the Consumer Protection Act to conclude this first part. Okay, so how is it contract of personal service? The service as mentioned in this act is explanatory, inclusionary, and exclusionary, as we have understood. The court, using this particular precedent in the judgment, has said that the correct method of approach would be to consider whether, having regard to the nature of work, there was due control and supervision by the employer or not. So, to find out whether this contract of service has been there, you have to see whether due control and supervision by the employer has been done or not. That is the first part of our discussion. Now we move to the second part, that ma'am, if not Consumer Protection Act, then which law? So the court has in this case clearly mentioned also that merely because we are saying it will not fall under a Consumer Protection Act does not mean that you do not have remedy. You have remedy under Advocates Act, and at the same time, Advocates Act is a special law as compared to Consumer Protection Act. So while this is a general law, in context of Advocates Act is a special law, and the special law will have supremacy over the general law, as we all understand. Okay, if you do not know, just know that there are two set of laws which we categorize and recognize. There are certain laws which are general in nature, for example Indian Contract Act, for example your IPC. Okay, and please write down in the comment section that if Indian Contract Act is general law, what will be the special law for it? In this comparison of Advocates Act versus Consumer Protection Act, the court says when you're talking about the remedy to be given, this can be considered as a general law because it will give remedy to all the people covered under it. But for the services rendered by the advocate, we also have a special law that is so there. Okay, so you have other remedy, you have other window of remedy. It's not that no remedy is available to you. That is the first discussion. Secondly, we also, when we try to find the answer of whether professionals are same as business and trade, the court has negated and the court has said that these are different and they are not same as business and trade. As I told you, the court referred to firstly purposive rule of construction. Whenever we read any law, we have to find out the purpose of the law. As I told you, the purpose of Consumer Protection Act can be read and can be seen by in the preamble, in the long title, in the debates, or in the bill. Everywhere you try to navigate and find that what is the purpose of this particular law. And from that, we understood that it was the purpose was to protect the interest of the consumer primarily from the the bad business practices. And that is why we have different, as I told you, 2019 addresses a lot of challenges. All those challenges are something driven and related to business and trade practices. So the court has used this point and said professionals are different. Then the court also says that if we align professional services wherein one person is acquiring degree, one person is entering into the act, which is more mental rather than mechanical, it will definitely be defeating, or it will be the wrong construction of law. So we do not want to construe the law in a wrong manner. And these are examples, as I told you, all these changes that have been done: misleading advertisement, e-commerce regulation, expanding the definition of consumer, passing of goods. All this has been addressed. All this relates to business and trade practices. Okay, so therefore the court has answered that professionals are different from business and trade. Now we move ahead. The court also says that legal professional is different from other professions. So as I told you, that a lawyer has four-faceted duty. Okay, the lawyer has to be dutiful towards the court, and this is the most supreme duty. Your duty towards the court, because you're an officer of the court, is most supreme. Then you have duty towards your client, towards your colleague, as well as towards the society. So therefore the court says that it is not so in case of other professionals. That is one thing. Then the court also highlights and recognizes that why do we need lawyers? I remember IMA versus BP Shanta is one case wherein very, which has been recognized and which has been later criticized also by when we say that if a medical professional has this fear in his mind, how will he perform surgery with shaky hands? right? Likewise, if the lawyers apprehend that if I do not, the chances of the client not liking the outcome of the case, there are two parties, one may not always be happy with the ending of the case. Therefore, the chances of the client, when he's frustrated, when he realizes that I did not get the remedy from the other party, now my option is that I go and sue my lawyer. So the chances of suing the lawyer becomes much more higher from a disgruntled litigant, and that is why we are trying to protect it. We are, and this approach is called as consequentialist approach, wherein you see the consequence of the judgment that you are writing, wherein you see what will be the outcome of whatever I am deciding today in the interest of public, whether it will actually lead into, or whether it will actually, ferment into helping the individuals and public at large or not. So that is why the role of a lawyer is inevitable, and we have to ensure that the protection is so granted. But that does not mean that we are granting absolute or blanket profession. And then it is a noble profession, and they are officer of the court, and it is not commercial per se. So we are recognizing. And see, do not get confused. Do not think that, okay, ma'am, we have said this for legal professional, but medical professionals are equally same. Are they not doing their duty, which is noble, which is not commercial per se? So just remember that the court has highlighted and the court has quoted here that we need to revisit the previous case of Indian Medical Association versus VP Shanta. We have to address it again. We have to go back and see the reasoning of it, and again in the present context try to highlight it. And all of this is happening because of 2019 amendment, okay, because of the changes that are so introduced, because now the judiciary is clear that despite of these landmark judgments previously given, we still have not made changes in the Consumer Protection Act in context of including these professionals to fall under the ambit of the act. And that is why the court is confidently now saying that we have to revisit the previous judgment as well. Okay, then the court has highlighted an answer that medical professionals and legal professionals are different. As I told you, there is no scientific formula here, right? You may reach to the court, your strategy may be different, your strategy will be dependent on the other party also. The other party doesn't come only, right? All ex parte proceedings. So how are you really going to challenge the conduct of your lawyer? So the lawyer doesn't have scientific standard to assess, or we do not know that what is the best practice that must be followed in every situation. So there is no universal standard for legal professions. The legal profession is based on contract of service, and therefore these are different from the medical services that are so given. Okay, so I have mentioned this. I've already told you that how even though they are enrolled in the state bar, they do not, get to be the lawyer unless they get the signed copy from their client showing the interest that they are okay with the fact of the lawyer going and representing them. Okay. To win a case, it not only depends on the skill of the advocate, but on exterior factors like opposite party and the other party and your own client, how they are behaving and how they are actually working. All right. Now, as I told you, the court has identified the need to revisit. We can look at it also. Now, what I'll do is that I'll take you to the copy of the judgment. Okay. See, every judgment that I teach you, I know that I request you to at least once glance through the copy of the judgment if possible. But here, this is only 55 pages long. If you are somebody who is preparing for judiciary and in that state, Consumer Protection Act is covered, try to at least give a glance through, to this particular judgment. There are various things that I've highlighted here, and that is how I'll tell you that how is this very important. All these arguments as to Advocate Act is a special law exclusively dealing with a particular mechanism, right? The legal profession is a noble profession. Autonomy is needed to preserve democracy. Then the advocate has various set of duties, and therefore all these are leading into the point, that this is sui generis in nature. Then we have bar, which has disciplinary power, which can take action against the advocates as per the Advocates Act. We recognize that we have the window of taking the remedy by way of a civil action as well, right? So you always have the option of taking the remedy by filing a civil suit, and that is also not something that is debarred or that is not told to you. So that is also there. Then if we move beyond and we try to see this, we also acknowledge the fact that, we have other windows, and we recognize and we realize that all these multiple forums and all these multiple remedies will be sought by the parties if we do not really grant them protection right now. Okay, so the losing party can always exploit the lawyer and say that, okay, there has been deficiency in the services granted by them. All right. So the only reason of me showing you this part of the judgment is that if you go through all these arguments, you will get more clarity. You have a lot of precedents mentioned here, which tells, that how consumers are different, to be seen differently, how the law was made with an intention. Like, for example, this with an intention that, that they are not exploited both by traders and manufacturers. So this is something which the court has highlighted, and the court is recognizing and saying that this is, this law is for protection from the traders and manufacturers. They nowhere are, very vocally speaking about the professionals to be included. So this is important for you to read the judgment. Then I have already covered that how the advocates and the services are sui generis in nature. Then the third question was whether the services hired would be said to be a service under contract of personal service. So here the question has been answered. Firstly, that the disciplinary powers are there. Secondly, we see the definition of section 242 of the Consumer Protection Act, and we recognize that it is different in nature, right? Okay. Because of direct control and other factors. Now, I will take you straight away to the conclusion part. When you refer to the conclusion part, the court has said yes to all the answers, right? So if I now stop here, and if let me ask you these questions, that if I say, or if you get a question that whether the advocates or the legal profession is sui generis or not, your answer would be yes, it is sui generis. Why? Because it is dependent on certain factors, right? Because here we recognize that there is no universal formula, there is no scientific formula, there are multiple external factors. Then we recognize that the duty of the lawyer is very different in nature. And let me just tell you, I have prepared a diagram for you over here. You can also refer to this diagram. You can take a screenshot of it, and then this will be a summary for you. So if you refer to this, why advocates will not fall under Consumer Protection Act? First, sui generis, the answer is there. No universal scientific formula, four-facet duty that is there. Then the business professions, business and trade is different from the profession that is to be exercised. And we recognize this by way of purposive rule of interpretation, okay, which means nothing but to find out the purpose of the law. Then the second aspect is that whether the services rendered by the advocates are contract of personal service or not. Again, answered, the client control is much more higher. We recognize the practice of wakalatnama and the idea of why a wakalatnama has to be signed. And then we also refer to section 242 of the Consumer Protection Act, by which we get a clarity as to contract of personal services are absolutely excluded out of the ambit of consumer protection. Thirdly, do not feel disheartened. Do not see it in a negative manner. You always recognize that we already have a alternative remedy. Rather, a special law already recognizes and governs these practices or deficiency in services by the advocates. And the last and the important part, as I told you also, whenever you're writing your answer, I think I took this help in Sita Soren also, and I'm again telling you, you can always see the judgment in the lens of consequentialist reasoning, okay, that what will be the consequence of holding, whether this should fall or not fall under the ambit of the particular law. So I hope this has been easy for you to understand. If you still have any doubt in the case, you feel free to write it in the chat box. Feel free to drop a comment. If you are not attending it live, you can later also drop a comment in the comment section. All right. So we stop here, and I hope to hear from you. I am requesting all of you again to drop your recommendations if you want us to cover any particular judgment. Right now, what we are doing is that we are covering the landmark cases from 2024. These are all landmark judgments which are from the subjects that are asked in different state judiciary exam. So we are keeping state judiciary in mind, but at the same time we also understand that if you are studying in college, you may have different subjects which may be different, and you can definitely let us know for us to cover that for you. All right, thank you so much, all of you. I'll see you again in the next class with another judgment, and hope to see comments this side from all of you. Thank you.